Now, for a contract to be formed, there must be acceptance of the offer. And you need to understand that acceptance can be by word or by conduct. However, when you talk about conduct or implied acceptance, then two things have to exist. One, you have to be aware of that offer. That's number one, because you can't accept what you're not aware of, right? And two, you must be willing to accept. So everything about your behavior should suggest that you are aware of the offer and you're willing to accept it. That is if you're going with behavior as a way of determining whether the offer was accepted or not. In the absence of these facts, the acceptance may be actually rejected. So think about this scenario. Let's say you go to a supermarket and you're buying something, okay? And then you see this product and it says, buy one, get one free. So if you pick that thing, and then you go to the cashier, you pay, and you walk out. And then when you're on the parking lot, you remember, there was that free thing that I was supposed to get, and then you come back. So if you ask for the free thing, is it a must for them to give you that? And the answer is no. So in fact, if they give you the free thing, they're only doing it for public relations purposes or for customer care purposes, but not for legal reasons. Because when you paid and you walked away, what you're telling us, actually you're telling us two things. One, you're not aware of that offer. And even if you're aware of the offer, you're not interested in the free thing, so you're not willing to accept it. That is what your behavior says at that point. Now, if you say, well, but I forgot, it doesn't matter because forgetting is not the same as accepting, okay? So, in fact, when you come back, that is now past consideration because the contract has already been executed. So, acceptance must be absolute and unqualified. Meaning what? Meaning if you add your own terms to acceptance, then what you're doing is you're countering it, okay? You're countering an offer, okay? For example, if somebody offers to sell you their car for, say, $5,000, okay? And then you say, yeah, that's a good price. I'd like to buy it for $5,000, but could you also change the tires before you deliver the car? So that is not you accepting the $5,000 offer. What you've actually done is you've modified the offer. You've said, I'll pay $5,000 on condition that the tires have to be changed. So you've just countered the offer and then you've made your own conditional offer. So acceptance must be absolute and unqualified. Next, the request for information is not acceptance. Okay? I mean, if you say, I'd like to buy the car, that's the message you write. I'd like to buy the car, but I'd love to know how much it's costing. And then the person says, well, it's costing $5,000. That is not the same as you making them an offer to buy the car. That is just you requesting for information regarding that car. So that is not acceptance. Look at this example. D offered to sell P certain items for 40 whatever, indicating that, so for 40 shillings, or indicating that the offer would be held open until the following Monday. P was a broker and would only buy once they had lined up a buyer to take from them. On Monday, P sent a telegram to D, sounding out what flexibility there might be to negotiate before the day's trading got underway. Please wire whether you would accept 40 for delivery over 2 months, if not longest time limit. There was no response from D, and P later purported to accept the original offer. D claimed that acceptance was not effective as their telegram had rejected the offer by way of counter-offer. Well, it was held that the telegram was not a counter-proposal, but a mere inquiry, which should have been answered. It was not as a rejection of the offer. So by asking questions, if you're just seeking information about the offer, that is not a counter-offer, okay? And it's also not necessarily a sign of acceptance. It's just you requesting for more information about something. Acceptance must be communicated. Again, that is very important. As a general rule, the same way an offer must be communicated, the person who makes that offer should also be aware that you've accepted their offer. Now, regarding whether they get the acceptance or not, that is something else, because if you're using a post office, then it could be the case that they didn't receive the letter, but then we look at when the letter was posted as a way of determining if that offer was accepted or not. In certain circumstances, the offerer may waive the necessity for communication. This occurred in Khalil v. Kabolik Smoke Ball Company, 1893. A newspaper advert placed by the defendant stated that a $100 reward will be paid by Kabolik Smoke Ball Company to any person who contracts the influenza after having used the ball 3 times daily for 2 weeks, according to the printed direction supplied with each ball. A £1,000 is deposited with Alliance Bank, showing our sincerity in the matter. Miss Khalil purchased the smoke ball and used them according to the direction and caught flu. She sought to claim the stated $100 reward. The Court of Appeal held that Miss Khalil was entitled to the reward as the advert constituted an offer of a unilateral contract, which she accepted by performing the condition stated in the offer. So notice in that case, she didn't have to say that I've accepted your offer. Okay, she simply acted on that offer. And so by acting, okay, by her behavior, it was deduced that she had accepted the offer by the pharmaceutical company. So that's the thing. It's not always the case that every time we have to communicate acceptance. Well, sometimes the communication actually comes in the form of behavior. And that is why we said acceptance can be expressed or acceptance can be implied. So that's the thing you need to know about acceptance. Obviously, if you have a question, do ask.